Welcome everybody to the Saturday night free online civics class on the Vocational Science of Freedom Gilded server. And tonight is class 4, which will be covering the Vocational Science of Freedom Status Docs. You can locate the information for this class on the Gilded server in class 4 docs and links. And if you're not a member of the Gilded server, then you can join the Gilded server by joining and subscribing to the Vocational Science of Freedom YouTube page and clicking on the About section, and then going down to the links and clicking on the VSOF Gilded server link. And tonight we'll be covering the status docs from the standpoint of binding arbitration. And what we're going to be covering is a part of the kill warrant, which is what we affectionately call a very long-winded title of a document, which is lawful claim of title, will, execution of will, declaration of status, appointment of trustees, and standing orders for same, which is just one of the Vocational Science of Freedom status docs. And I'll get into and show you guys the process for doing binding arbitration against a trustee who has agreed to enter into contract when you serve them with this particular document. And this, of course, is also the Vocational Science of Freedom status docs also claim your entire estate. So this is after the point of which you've made claim to your entire estate. You've claimed it on the public record. You've done a proof of life and proof of age inquest by a judicial coroner, signed by a petite jury, and all the rest of the processes before you get here. So this is kind of after you've done the rest of the process and had your house seal made and gotten your birth certificate authenticated and all the rest of the fun things that we do here. And then this is after the fact. So who gets served? We've had a lot of discussion about who should be served the entire status docs, your entire status doc set, and in what way. Now, I don't mean in what way as far as how do you serve them. Obviously, you do personal service, and you can either do that by a process server, or you can do it by anyone who's over the age of 18, who then serves the doc set on whoever may or may not be coming up against you, or whoever you want to place on notice, so that if they ever do come up against you, they will have notice of your status doc set. And in this particular document, this long-winded document that I said, this is what we call the kill warrant. It's what we affectionately call the kill warrant because it was, in a way, has been used to literally kill warrants off of people's estates. It's also been used to do a lot of other things, including getting multi-million-dollar arbitration awards against sitting judges, which I will show everyone before the end of the night. I'm just going to read this beginning of the KW, and there's a whole heading section up here, but I won't get into that because that's all. It's just your boilerplate type heading stuff. So I'm just going to read the opening paragraph and just to show people how extensive these documents are and how complete they are. This particular document, as I don't know if you can notice, it's version 10.0, which literally means that this document has gone through 100 revisions. 100 times this document has been proofread, checked, fixed, updated, altered, bettered, if you will. And it's now to the point where all of us who've been working on it for over 15 years consider it to be absolutely perfect. If anybody wants to argue with me about anything that might be in here one direction or the other, you're welcome to do so, but I can guarantee you're not going to win that argument because every single word in here is meticulously picked and researched and checked. Its definitions have been checked through multiple different dictionaries, and it's been, like I said, it's been proofread over 100 times. So let me just get into reading this. So this is what this is. So what are we doing here? So we're coming now, and again, this doc, along with the rest of the status doc set, gets filed onto the county recorder's office under either wills or miscellaneous or anything else that basically they'll allow you to file it under. It's really not important what it gets filed under as long as it's on the public record on the county. And no, it does not have to be your birth county either, because all of the states have equal standing with all other states, and they have to recognize the documents and the court findings and rulings of all other states. So to start, so comes now, and this is all redacted. So comes now, John-Henry, of the house of Simon, who is, a man or woman, having been found to be living, having come to of full age, that's out of the Magna Carta, a living soul manifest, one of the people of whatever state you're lawfully domiciled in, an American, a free woman or free man, whichever the case may be, a freeholder, which means you hold an estate. An estate does also not just mean land. An estate, the substantive definition of an estate is everything that a man or woman owns in law. Okay, so just so you know that. In a free state of being, this is in reference to the Second Amendment also, because when it talks about in the Second Amendment about the necessity of a free state, they're talking about a free state of being in the Second Amendment. They are not talking about New York, Pennsylvania, Massachusetts. Okay, they're talking about a free state of being, of one's own free state of being. That's what the Second Amendment means. So that's why that's in there. Legitimate issue. That issue is what they call children. So that's an issue. Legitimate issue of lawfully wed parents and fully emancipated, meaning you don't have anybody above you. Hereinafter claimant. Upon this, and then you repeat the name of the document, which is in the form of a formal lawful juristic act, a lawful claim at law, deed, will, execution of will, appointment of trustees, an offer of contract, that is, tacit, implied, bilateral, and formal in nature. That's the type of contract it is. A covenant under seal, because it is sealed, so it's not just a contract, but it's also a covenant. The continued wish and will of the claimant, which also contains a list of executive orders under seal. 2, the named and appointed trustees hereinafter claim. So everything that I said from here all the way to here, I never have to repeat again in the whole entire document. All I ever have to say after this point is claim. It's all of this. That's what claim is, period. The duly authenticated title warehouse receipt, also known as a birth certificate, attached to claim, bears an endorsement from claimant, which claims and demands the return of all property and res regarding John Henry Simon. And this would be the name on your birth certificate, exactly how it's printed on the birth certificate. It's not necessarily the upper and lowercase thing. It's not necessarily the all caps thing. It's exactly how it's printed on the BC. Okay. To claimant, period. And claimant is the donor, grantor, owner, settlor, testator or testatrix, as the case may be, so lawfully appointed absolute general, instituted rightful executor or executrix, as the case may be, and so lawful general forced legitimate testamentary unconditional heires sus. That's just 3 different ways to say heir. Okay. Of all trusts, lands, infants, persons, vessels, bodies, estates, sesquicae trusts, and fictions of law that are named or known as, and again, this is the name on the BC, hereinafter estate. So everything that I just said, of all this stuff, right? Of all of what the estate is, all these various different things here, that's all now estate. So every time that you see the word estate, it means all that. And John H. Simon, also known as all other derivative names, idem sonans, which is what that means in Latin, and spellings thereof, hereinafter trust or trust. So any other possible name that they would ever place or use in any constructive trust, meaning any court case, or the Social Security trust, it doesn't matter what the name is. All other derivative names, okay, you're now calling trust or trusts that were created, birthed, or established on or after birth date, that's the actual date that you were born, and possibly registered or recorded without the consent of claimant with or to the state of, and then whatever the birth date was that you were born in, the county of, whatever that is, and the name of hospital, whatever, comma, the United States and or the DTCC, that's the Depository Trust and Clearing Company, and possibly other unknown parties on or after, and then the registration date of the BC, which is on the BC with the date that it was registered. Period. Claimant now, of claimant's own volition, free will, act, and deed, declares, orders, executes, admits, offers, acknowledges, charters, test days, appoints, claims, and establishes on and for all public and private records, and for all courts, in all realms and seas, under penalty of perjury, the foregoing and the following, colon. That establishes everything that you are throughout this entire document. It also establishes the vast majority of everything that you are in every other single Vocational Science of Freedom document, to make sure that we're uniform in everything that we say all the way through the entire doc set. Okay, so there was, and I wanted to make sure that people understood how thorough these documents are. That is just the opening paragraph. There is 33 pages of this document, and every single word in here is, yes, necessary. So yeah, basically everybody who basically isn't a member of your own house gets appointed as a trustee. Now, they don't accept the offer of being a trustee of your estate until they administer your estate. That's the clause. That's the binding action clause. And I have explained this in multiple ways, but the best way to explain it is basically like this. If you own land and you put up a fence and say, this is the borders of my land, and then you put up a sign on the fence that says no trespass, violators will be subject to such and such contract. And then you put a contract on the fence. If someone jumps your fence and just decides to walk across your property because maybe they've been doing so for a while, like say maybe they want to go and walk across and go pick some berries on the other side of the woods or something, and they don't feel like walking around your property, walking around your land. Do not confuse those two terms, by the way. It's land. So they don't want to walk around your land, so they want to walk through your land. You say, hey, stop doing that. And the guy says, I don't care. I've been walking across this land before you bought it. I don't give a shit. You say, well, it's mine now, and you're going to have to. He says, I don't care. You say, great. So you put up the contract. You sit on your porch. You watch the guy jump the fence with a friend of yours, sitting on the porch drinking a beer, perhaps, and you yell out to him. You say, hey, you're on my land. You've entered a contract. He says, I don't give a shit. And you say, hey, well, I've got a witness here. He says, I still don't give a shit. It's okay, great. See you in court. So what has he just done? He's willfully entered into the contract, and you have a witness that can prove that he's done so. That's it. That's a lawful contract. It's on the fence. He's been noticed of it. And just like we notice all of the trustees through serving the Secretary of State, which notifies basically every officer of the state, whether it be, Wisconsin, New York, Illinois, whatever, doesn't matter. And then you can serve whoever else you want to after that. So say if there's a court coming after you, can serve an inferior court. You can serve judges, obviously, which is what I'll be showing you later. And you can serve the United States Federal Corporation by serving the Secretary of State. Oh, it's always the Secretary of State that basically has to then give notice to every other agent or agency of a particular corporate government after you serve them. And someone had once told me, even though I have not yet been able to track it down, that there's some Texas statute that says that if you serve the Secretary of State of Texas, that you automatically then are serving or placing on notice every single corporation that is registered with Texas. Now, that would be interesting because you could certainly check off a lot of boxes if that's true. But I have not yet been able to find that, and I haven't really had the time yet to go track it down. But anybody who's listening to this, please feel free to put in a comment in the video section on YouTube, or to inform me on the Gilded server if you find out of that particular statute in Texas, or any other state that you might find it in, regardless of what state you might find it, or if maybe it might even apply to the feds in some way somehow, that if you serve the Secretary of State. But I think I doubt they do that. That might be a little bit too farther reaching, but okay. So to continue with this, appointed trustees, appointment of trustees list. Claimant now by the rights of blended kinship, the common law, the law declared in this claim, the Powers of Appointment Act of 1951, Title 26 USC 2514 BD, and all other applicable law, hereby appoint the following enumerated through I through XXXIII, which is 33, below, as trustees of the estate and trusts herein. As appointees of the estate and trusts, which is what I spoke before in that opening paragraph. So everything that the estate and trusts are. So we're appointing trustees to everything that we said the estate and the trusts are in the first paragraph. Okay. So herein, appointed trustee or appointed trustees or just trustees. All courts, that's any court in the entire planet, period, that wants to try to administer your estate, they automatically go under the bus. Corporate or otherwise, all 501c3 organizations, not including claimant's own superior court of record, the court of claimant's house, nor claimant's probate court. Because if you were going to appoint yourself as your own trustee, you'd be a little bit dual-minded there. So your courts, the courts that you control, are not part of it. All right. 2, the state of Iowa, and you'd put there whatever state you're lawfully domiciled in, because you'd put them basically into the bus first. All 50 states in the union, all states, notice I said capital S state and lower S state. So all capital S states, all lowercase s states. Not including claimant, because you technically are a lowercase s state, as I said, right? Second Amendment, free state of being, right? Lowercase s state is what consists of. Uppercase s state is what occupies, right? So make sure that those two things are always clear in your head. So again, we're not appointing ourselves as a trustee. 3, United Nations, UN, United Nations, the United Nations, sorry. It's basically every different way you can spell it. And then we go to the United States, every way you can spell that. United States of America, every way you can spell that. District of Columbia, and everything that they are, every way, shape, or form. All, and I said all incorporated and unincorporated governments, not including the government of claimant's own house, because technically you have, you as the, if you're a male, you as a paterfamilias of your own house are basically the government of your own house. So I just want to, again, we're not appointing ourselves as trustee here. All military branches of all governments. I don't give a damn what country it's from, doesn't make any difference. Okay. If they try to administer you, bam, they're under contract. All incorporated, unincorporated cities, townships, zones, states, provinces, territories, districts, regions, areas, sections, sectors, hamlets, counties, towns, turfs, villages, parishes, boroughs, manors, shires, municipalities, conclaves, and enclaves. Sorry. So basically all of the municipalities you could possibly throw in there. They're all under the bus. All police departments, for all of the same things I already stated, including Interpol. All law enforcement agencies. All sheriffs, same deal. And all coroners, same deal. But of course not including, well, your own appointment of your own judicial coroner literally takes him out from being a trustee of your own estate. So you give him your own orders when it comes to your own judicial coroner, which you appoint for your own house. All public and private utility companies, all public and private power companies, all chartered and unchartered corporations, associations, and companies. Every single filthy ass corporation out there that would ever try to administer your estate, and I do not give a flying fuck in what way, they get put under the bus. That's it. All of them. And there have been plenty that have been put under the bus, and they have ran from this document like it was holy water, which it basically is. All bar associations, American Bar Association, the Bar Foundations, IBA, Northern Trust Corporation, the City of London Corporation, the Temple Bar, the Crown, all Inns of Court, all temples literally throws all the rest of them under the bus too, any secret society temple, American Law Institute, the Knights Templars. So that's pretty much all of your occult stuff from the standpoint of the Bar Association is under the bus. All bonding and holding companies, all insurance companies, all accounting firms, so on and so forth, all trust companies, so on and so forth. The all incorporated, unincorporated banks, all your banks are underneath it. International Monetary Fund, under the bus. Internal Revenue Service, under the bus. United States Department of Treasury, under the bus. Now, technically, this is already covered, but I just want to make it specific whenever it comes down to it. All intelligence agencies, under the bus. All technology companies. Now, this is technically already covered in corporations, but I wanted to be specific in case these people really get out of hand. All federal law enforcement agencies. That's everybody. All prisons, all jails, everything. The President of the United States of America, that I wanted to make that specific so that when we serve them, we can say, look, number, what would that be, 26, So we can specifically say, hey, number 26, you were specifically named. So what are you doing? The Vatican City, the Pope, Papal Carbonary Corps, the Gendarmerie Corps of the Vatican, Holy City State. Basically, this puts all of the cult of Rome under the bus. All of it. All of it is under the bus here. The United States Postal Service, the corporation side. And then I go completely global as far as the bloodlines, throw all them under the bus. All emperors, empresses, kings, sultans, queens, monarchs, princes, so on and so forth. All hospitals, knights hospitalars, all health clinics. That gets rid of the meta part from meta, soma, and veta, the three ways that they take from you: medicine, psychology, and law. All medical health facilities, in case that wasn't specific enough. All established houses of all civilizations, cultures, creeds, not including claimant's own house. So I just put every single other house under the bus of the entire world. Now think about that. Who does that put under the bus? Rothschilds, the House of Rothschild, and the Windsors, all of them. They want to try to administer your state? Great. They're under the bus too. And all of the respective, and I'm not going to read this entire list because it goes on for an entire page, but I'll read some of it. And all the respective subsidiaries, franchises, bailies, bailors, relations, divisions, departments, precincts, principalities, princedoms, capitals, communities, agencies, associations, bureaus, federations, confederations, brotherhoods, sisterhoods, societies, groups, guilds, charities, organizations, plaintiffs, defendants, administrators, soldiers, guards, deputies, councils, guarantors, chairmen, chairwomen, couriers, messengers, spokeswomen, magistrates. I'm skipping all over the place, obviously. Congressmen, parliaments, legislators, statesmen, personnel, retirees, contractors, subcontractors, and representatives thereof, whether said be quasi, real, fictional, de jure, de facto, absolute, conditional, chartered, unchartered, uncorporated, incorporated, governmental, non-governmental, official or unofficial, and of all other listed and enumerated in I through XXXII above, as if completely listed herein in all places where said may be found or located. You just threw the entire world under the bus. Okay? Any questions? Yeah. Now, when it comes on to the arbitrator, so we give the arbitrator limited immunity from liability in case the arbitration company wants to get snarky, we can run them over too. But we basically give them an out in the front here. Any arbitrators appointed by claimant that conduct any hearings or give any awards regarding the dispute arising from claim, this whole thing, in the immediate issue, they are appointed to arbitrate, are not included herein as a appointed trustee and do not need to post the bond stated in 12A below. Failure to stay within this limited scope at the claimant's sole discretion shall result in the arbitrator also accepting and becoming party to this contract and all liability attached hereto described herein. So that's our backstop for in case the arbitrator wants to get really stupid. So that's just a little connection and some of the reading of what's in the affectionately called the kill warrant, which is only one of the 10 or more status docs from the Vocational Science of Freedom. I say 10 or more because some people end up having to do a couple others if they have court issues which they have to deal with, which would be the marshal appointment and the special master appointment. So what happens if somebody does any of these things? Well, actually, you know what? Hold on. I'll read one little more part down here about the binding clause. So this is how people become bound to this contract. So binding clause of appointed trustees. So this is what they have to do, and then they bind themselves. Just like remember the guy who jumped the fence? Okay, he read the contract and then he jumped the fence. Okay, his choice. So the appointed trustees, according to their actions, binding them to claim, as stated herein, fully agree to be bound by free assent, meaning that's of their own bloody volition, by their own accord, to the various degrees of absolute obligations, duties, terms, conditions, requirements, and warranties stated in claim. These decrees and various levels of binding actions and agreements are listed in the following binding clauses. Binding Clause 1, Binding Clause 2, Binding Clause 3, Binding Clause 4. These get progressively severe as to what they do to bind themselves to each clause. Now, again, I'm not going to read each clause tonight. If you want to know what they are, then get your doc set done. Okay? But the binding clause is listed and the power is vested under good behavior from claimant to the appointed trustees, and list the clauses and duties owed to claimant from the bound trustees. So they're all clear. So I will read binding clause 1 here. Any administration of the estate or trust or claimant and any actions taken by the appointed trustees herein for or against what is listed in list below. Now, the list is basically everything that you could possibly attach to the estate, and that goes on for 3.5 pages, which I'm definitely not going to read. Including but not limited to any administration by any court action regarding the estate and trusts by any appointed trustee, enumerated through I through XXI above, which was the list that I did just read, or any other third party whatsoever. So in case I missed anything anywhere, great, there's your catch-all. Hereinafter, binding action 1 will be their full binding agreement, free assent and acceptance by their own free will, accord, and volition of all that is stated in claim. This does not include any adherence and fulfillment of the specific executive order stated herein that do not bind one to claim, which there are a few, meaning if they don't want to bind themselves to the KW, they can do the specific things which we tell them to do regarding our estate and then be gone. Do not ever do anything with us again. Do not ever do any accounting with any of our estates. Do not send us anything. Nothing. Don't even hold a record that we exist, because that also is included as a type of administration. So, to continue. All the clauses, obligations, powers of attorney, executive orders, stipulations of fact, claims, decrees, sections, declarations, clauses, definitions, binding law, submission to binding arbitration agreements, court of record proceedings, warranties, terms, and conditions stated in claim are herein referred to as clause or clauses. So guess what? I never have to repeat any of that shit ever again. Everything that's in there, everything from that sentence on, all that is now clause or clauses. Done. Any appointed, this is a trick that the attorneys use against everybody all the time to throw in a whole lot of stuff into one term. Well, what did I just do? Same thing. What's good for the goose is, you know what. Any appointed trustee who has bound themselves by performing any binding action stated herein to any degree stated herein immediately agrees to be and shall be referred to herein as a bound trustee or bound trustees. So the second that they do any of this stuff, they're a bound trustee. That's it. Bound trustees agreed to faithfully carry out and execute all clauses of claim, as stated herein, within the term stated herein, after being served with claim or having notice of claim. Because, of course, you can't throw them under a bus under a contract that they've never had notice of, right? So you have to process it first. Notwithstanding any request from a bound trustee for more time to perform said, as stated herein. I do give them an out if they're like, wow, this is enormous, but I want to make sure that I do what's necessary and not mess this up. Can I please have some more time? Yes, you may, but only by written agreement between the two parties. All appointed trustees who perform binding action 1 shall be hereinafter trustee in honor or trustees in honor. Trustees in honor are vested by claimant for 120 days with all the needed powers to fulfill all executive orders herein and any other executive orders given to them by claimant, which may be above and beyond and in addition to what is stated in claim. A trustee in honor shall remain so until discharged by claimant or until 90 days of non-performance of the clauses they bind themselves to herein, at which time they agree to be a trustee in dishonor. See, if you want to be a trustee in honor, that means you're being a good boy and you're doing what you're supposed to be doing. You go to a trustee in dishonor, there's a whole level of sledgehammer that comes down on you. But again, that's for those who've done the doc set and want to put the sledgehammer on them. Furthermore, all bound trustees until they are discharged by claimant, as stated in section 6 below, agree to be bound and be under absolute perfect obligation to perform and obey all the controlling clauses and listed in section 6 below. Agree to stipulate to all facts listed in section 7 below. Agree to be and shall be fully bound to all law stated in section 8 below. agree to understand and stipulate to all definitions listed in Section 9 below, and agree to all terms of binding Clause 1 listed in Section 11 and elsewhere below, unless otherwise stated herein. Any actions of dishonor or actions of default or any other binding actions of administration as stated herein by any appointed trustee shall bind them to their respective binding clause as stated in claim, as well as preceding binding clauses regardless of any other administration stated above. Meaning the second that they do some of these things that would bind them to, say, be a trustee in dishonor, or that they do that it's under binding clause 3 or 4, they're instantaneously put under the bus for all the rest of the clauses. So it's a if you touch the flypaper, you're stuck to it kind of thing. Furthermore, all bound trustees agree that all clauses in claim are valid and enforceable against them, and that all clauses are owed unconditionally without any kind of offset, defense, argument, demur, or counterclaim on the part of any bound trustees, regardless of which level of binding clause they have chosen to bind themselves to as stated in claim. That, my friends, just got rid of any of their defenses. They can't come in here and say, oh, I didn't understand the contract. Too bad. It says right there that you waived that. I am being as absolutely vicious as law can possibly allow. They choose to cross this line in the sand, they are done. We can bankrupt every single corporate government with this contract. Period. If people would simply use it and stand on it. Now, let me show you what happened to someone who actually decided to do that. This is an arbitration award. This is an arbitration award against several sitting judges and a district attorney. This is real, and this is final. When you go into binding arbitration, the other side has 90 days to basically say, hey, I didn't agree with the arbitration, or it was unlawful, or basically come with some sort of argument to offset it. If they do not, Title 9 clearly states in U.S. Code that they only have that time limit. Once they go past that time limit, it is considered cured, and God himself cannot change it. And 90% of the time, or even 95% of the time, depending on which arbitrators you talk to, but they'll all tell you that pretty much everybody doesn't bother to answer binding arbitration hearings. And they put themselves under the bus right from the beginning, right off the bat. And they don't even realize what they're doing. They don't realize what they've just done. So, final arbitration award. And by the way, this is an updated award. There was an award before this, and then this was the updated award that kind of got fixed because the arbitrator missed a clause that we specifically made a point of, and she said, "Oh yeah, sorry, yeah, no, that was my bad." So, and as you could tell, the thoroughness of the KW, that going on for 33 pages, it's okay. I don't mind sometimes that somebody might miss something. It's understandable. It's a very intense document, and it's very thoroughly loaded. And so I don't hold it against anybody that might not see it, but we can always correct the arbitrator. So, breach of violation of required contract terms. This is what I was just talking about, the KW. The parties have agreed that a judgment of the court shall be entered upon the award made pursuant to the arbitration and shall specify the court. Then, at any time within 1 year after the award is made, any party to the arbitration may apply to the court so specified for an order confirming the award, and thereupon the court must grant such an order unless the award is vacated, modified, or corrected as prescribed in sections 10 and 11 of this title. That's Title 9. If no court is specified in the agreement of the parties, then such application may be made to the United States Court in and for the district within which such award was made. Notice of the application shall be served on the adverse parties, and thereupon the court shall have jurisdiction of such party as though they had appeared generally in the proceeding. This basically gets done as a summary motion process. It's not considered a civil matter. It's a summary motion proceeding. Okay, if the adverse party is a resident of the district within which the award was made, such service shall be made upon the adverse party and their attorneys as prescribed by law for service of notice of motion in an action in the same court. That's just boilerplate for make sure you serve them. Okay, so there's all that. So where'd the hearing happen? It happened in Athens, Georgia, which this arbitrator has considered the claimant request for dispute resolution on complaint and finds as follows. So what do we serve them? The arbitrator was given a copy of the KW, a copy of the court case of which they administered the gentleman's estate, a copy of the court of record default case, which this gentleman sued out against them and defaulted them and said, you guys don't have jurisdiction. You defaulted. You never proved jurisdiction to my superior court. And they said, we don't care. We're moving forward. And he said, okay, I'm taking you binding arbitration. And they said, we don't care. Okay, great. So this is what happened. The arbitrator has subject matter jurisdiction as acknowledged by 9 U.S.C. and all the rest of those codes. The claimant, Brett Nelson, is a citizen of the state of Colorado, state citizen, notice that, and respondents, yada, 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 entered into a contractual agreement around such and such date. It is uniformly settled that a court's right to vacate or modify an arbitration award is extremely limited. That said, many state arbitration issues, as well as the Federal Arbitration Act and the Uniform Arbitration Act, allow correction or modification of an evident miscalculation of the arbitrator's award. See 9 U.S.C. subsection 11A. Many state courts have held that an award can be corrected only for miscalculations that appear on the face of the award and for mathematical errors that are plainly clear. So you see how limited this is? Once they get into binding arbitration and they have an award against them, you really can't get out of it. This arbitrator, Keisha Jones, has appointed in the above reference matter on behalf of Sitcon Arbitration Company to settle and resolve any and all disputes arising by arbitration under the authority of the Federal Arbitration Act. An arbitration hearing was held November 27th, 2019, at which time the arbitrator reviewed all contractual agreements and documentary evidence submitted by the parties in this matter. This arbitrator fully considered and granted the claimant's request for summary disposition and further considered all the evidence in reference to the contract item number. Now, this is a number that the arbitration company specifically put on the document. That's not a number that we use, but it's just a reference for them. Its terms, promises, and obligations, as well as the facts and support as presented during the arbitration of this controversy. On or about May 24th, the claimant and respondent entered into a written, irrevocable, binding contractual agreement. That'd be the KW, folks. Which included an arbitration clause, which does. Both parties entered into a legally binding contractual relationship, and this arbitrator found that no fraud in the inducement to the contract or fraud to the factum was present. You know what a lot of people have been trying to do? They've been trying to put people into contracts and saying, oh, you bind them to them, whatever, and the arbitrators will be like, there was an arbitration clause. There was no contract. Guess what? There's a definite contract with the Vocational Science of Freedom Status Docs. They are under the bus, and that's your proof right there. Thus, respondents are bound to the terms and obligations agreed upon and imposed on them. To date, the respondents have failed to respond to the claimant, and this arbitrator has found that the respondents were not willing to participate in the hearing. Notice that. What'd they do? They got notice of the hearing. They just didn't decide to show up. Doesn't matter. Therefore, careful consideration of the evidence presented, this arbitrator finds the follows. The claimant, as well as the respondents, are consenting adults, have attained the age of majority, not a minor, not an infant, not a delinquent, and or not a decedent. Notice that. The arbitrator made sure that your status was proper, okay? All parties are fully capable of entering into and negotiating contracts, and I do not find any of the parties to be suffering from a mental illness or disease or defect that would have prevented and or interfered with their knowledge and intention entering into the binding contractual agreement. The arbitration hearing was held on such and such date, at which the arbitrator reviewed all contractual agreements and documentary evidence submitted by the parties in this matter. The arbitrator fully considered and granted the claimant's request of September 3rd, 2019 for summary disposition and further considered all the evidence and referred to the contractual agreement. This arbitrator finds that the respondents have failed to fully perform to the terms of the agreement. Right? Because they didn't give a full accounting of the entire gross estate and then give livery of season of same. They kept administering the estate like they thought that they could do because they're too stupid to even understand how their system is set up. Meaning these private for-profit inferior courts that are not of record. A prior relationship did exist between the parties, and the respondent had an obligation to respond to the reasonable request of the claimant. That's right, because I've claimed my estate. You continue to administer it. You have to respond because of the reasonable request to ask you what the hell you think you're doing. This arbitrator finds that the contractual agreement is binding on all parties, remains irrevocable, and that the contractual agreement remains in effect as stipulated within the agreement until all the obligations are satisfied by the defaulting party. All the obligations. There's a hell of a lot of obligations in that contract, which I will not get all into. But one of them happens to be a very, very large bond, which we'll show you in a minute. As of this day, those obligations have not been satisfied, and I hereby order the respondents to satisfy the obligations according to the terms of the contractual agreement, which is not inconsistent with this order. And this arbitrator finds that the claimant has demanded liquidation of the estate trust and that the respondents have failed to act. What did we do? We told them what we'd... Yeah, liquidation of the estate and the trust. Give it to me now. You don't have any other claim on it. You didn't even argue it. And you completely defaulted in a court of record, and now you're getting defaulted into a binding arbitration suit hearing. Not too intelligent on their part. And trust me, they'll keep doing this because they're stupid. So to continue, the claimant has also demanded a full review and audit, comprehensive in nature, of all revenue of the estate and trust over the course of the past 10 years. Now, technically, that's not in the document. We technically say everything. It's a full accounting, but that's fine. I think it was something that the arbitrator put in for 10 years, and it might have to do something with IRS law. I don't know. We didn't argue that part of it. We're just like, fine, whatever. And or deductions associated with the estate and trust, a copy of the insurance policies held, and a copy of any bonds held by the debtor. The claimant, also acting as the creditor in this matter, has requested such information to preserve their standing and position. Right? So again, give us a full accounting. It is ordered that the following case numbers, and these are all the cases that they had against him, and any other cases against claimant, past and arising its judgments, orders, pleadings, papers, and sentences, are void ab initio. Notice that. The arbitrator just said that all the cases that they had against him were void ab initio. And the reason is because he defaulted them in his own court of record, as per you're supposed to, basically by a common law court of record saying, and suing them for jurisdiction and saying, what's your jurisdiction? They didn't answer. They went to default. 21 days. Bam, done. He served them. You guys defaulted. Here's the default. They didn't care. Okay. Clearly the arbitrator cares. Retaliation or any sort of backlash will result in the claimant recovering retaliation damages equivalent to 5 times the amount of actual damages if any further injury is inflicted. And by the way, they did exactly that. The respondent failed to provide proof that they have not received or have not been notified of the existence of the contractual agreement and or their right to waiver. And the respondents failed to respond to their contractual agreement mailed with proof of service by the claimant on September 25th, 2019, which constituted an act of tacit acquiescence. And the respondents have failed to fully perform to the terms of the agreement, and the claimant is entitled to immediate and unconditional remedy as prescribed within the terms of the contractual agreement. And furthermore, here's the fun part, this arbitrator finds that the amount stipulated to be paid to the claimant is $500,000 from respondent Carrie Ann Yoder. That is a sitting judge. This amount was derived to recover some of the loss experienced and for trespass of claimant's property and rights as stipulated according to the terms of the contractual agreement as agreed to by the parties. And 10, amount stipulated to be paid by the claimant is $500,000 from respondent Lori Beth Talbot, another sitting judge. this amount was derived to recover from some of the loss experienced, and for trespass of claimant's property and rights as stipulated according to the agreements of the contractual agreement as agreed to by the parties. And same thing again. Ashley M. Bergmeister, 500,000 again. And then last one is Donald Corwin Jackson, another judge. Actually, one of these is a DA. I can't remember which. It might have been Talbot. Anyway, so 500,000, 500,000, 500,000, 500,000, right? Total of 2 million. But remember, what did it say up here? Remember when it talked about 5 times the amount, right? Okay. None of them did what they were supposed to do after they got defaulted. So guess what? All of this goes to 5 times the amount. So this isn't 2 million. This is 10 million. Okay. The respondents have 30 days from receipt of this award to comply with the decisions of this arbitrator. In the event that the respondents fail to comply with the decisions of this award, the arbitrator may revisit this matter, which is exactly what they did, upon request of the claimant, and according to the terms and conditions of the contractual agreement, to modify this award in an amount equivalent to 2 times the determination of this arbitrator for each respondent. So they actually did it twice. They retaliated, and they did it 2 times. So guess what it's up to now? 40 million. The contract stated that any final and binding arbitration award may be confirmed in any United States District Court pursuant to Title IX, United States District Code. The Supreme Court has explained, quote, there is nothing malleable about must grant, which unequivocally tells courts to grant confirmation in all cases except where one of the prescribed exceptions applies, which would mean that they actually responded within 90 days and said, hey, wait a second, we don't agree to this, or you did this fraudulently, or whatever, to argue something, to at least do something. They didn't do anything. So they're in default. And after 90 days, it's cured, meaning they can never come back on it. A judicial review of an arbitrator's award is extremely limited, and the court must accept the arbitrator's credibility determination, even where there is conflicting evidence and room for choice exists. Meaning, even if it was like squirrely, kind of, if they don't do anything within 90 days, they're still bound to it anyway. An arbitrator's award should not be vacated for errors of law and fact committed by the arbitrator, and the courts should not attempt to mold the award to conform to their sense of justice. Arbitrators' awards are absolute, folks. And I can tell you why. Do you understand the history of law? Arbitration existed before Roman civil law existed. The first, quote-unquote, judges, if you will, of Roman civil law were not judges. They were arbitrators. They only arbitrated the matter between the parties. The state, meaning the Rome itself, the state literally took no cognizance one way or the other about what people basically did against each other. But what they would do is they would punish a defendant who resisted a judgment of a court for a plaintiff. So if they went in and they did arbitration, plaintiff won. If the defendant tried to resist, then they would basically condone any action that the plaintiff took to take back his property, or literally, and this is not a joke, to sell the defendant as a slave over the Tiber River. But that's a story for another time. 16. Claimant may seek confirmation of this award, arbitration award, in a United States District Court. Confirmation of an award is generally a, quote, summary proceeding that merely takes what is already a final arbitration award, a judgment of the court. Okay, so they make what's already a final arbitration award a judgment of the court. That's all confirmation is. It's a summary proceeding. It does not even involve filling out a whole civil cover sheet. It's very simple, and it's should, without question, be done instantaneously. Now, we've been running into certain problems regarding confirmation, but I'll get into that on another day because we're getting close to the end of the thing, and I'll finish out the document here, and then maybe next week we'll get into the situations that we've had dealing back and forth with federal courts regarding how some of them are acting almost schizophrenic because they see what we're doing and they're scaring the shit out of them. So anyway, number 17. This award is final and binding between claimant and the respondents in the above reference matter upon issuance and execution of this arbitrator's signature below, and full force and effect take place immediately upon issuance. So right there, you have an award. That's it. Now, how you decide to enforce it, you don't have to enforce it through U.S. District Court, or if they're going to be a bunch of pansies about it, whatever. We can enforce this however we want to. We can enforce it in another court of record. We could enforce it by, I suppose, in one way, shape, or form, we could probably even enforce it by grand jury if we wanted to. But that would require just 25 people coming together in their county and forming a grand jury that have done their doc set. But we've also talked about other ways of possibly confirming this through petite jury and summoning a petite jury through either judicial coroner or through possibly notaries, possibly. You know, you could summon a petite jury through a notary and get it done that way. But there's a lot of different ways to do this. And like I said, I'll get into the aspects of what the arguments regarding Title IX and yada, 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 and what they've been trying to do to stop it because they're scared to death. So anyway, so this is all the people that it got responded to, sent to, such and such. And here's the seal of the arbitrator and the notice, and that's it. And that's the end of it. So, and this was all the tracking numbers, and up top, even though I didn't show that before. So that, my friends, is how you do a binding arbitration against someone who has violated or entered into contract under the Vocational Science of Freedom Status Docs, and if they fail to perform as is required in the documents. And with that, it's going on about an hour. So this has been the Vocational Science of Freedom free civics class, where we covered class 4 docs and links, settlement of our estate. And next week, we will continue on Wednesday with our open brainstorming class. And again, if you'd like to join the Vocational Science of Freedom, and all you have to do is click on the About on the Vocational Science of Freedom YouTube page and go down to the links and click on the Vocational Science of Freedom Gilded server, and you can join in the discussion of all of us at your leisure. I thank everybody for showing up, and I'll turn off the recording and we can talk amongst ourselves. Okay, anybody got any questions? And by the way, I did not stop the recording, but I may just, I have to say that so I can cut it later after post-production. So. Examples of administering our estate. Sure. Various different examples of administering our estate, Carrie, would be to arrest you. Right? If a cop arrests you and puts you into a cop car, because the only thing they can possibly arrest you for is, or what they do arrest you for, basically 100% of the time, are commerce crimes. Right? So what is the commerce crime? It's an aspect of saying that, well, you as an infant didn't ask daddy for permission for a license to go do something that was lawful to begin with. Well, guess what? You're not dealing with an infant. You're dealing with one of the people who has claimed their estate and has you under contract. So an arrest is an example. A judge continuing a court case on said arrest, like say a traffic ticket. You serve them with the doc set and say, hey, you're my trustee now. And then you get in court, whatever, and you say, Your Honor, I come before this court as having been found to be living, and as the sole lawful executor and heir of John Henry Doe. Is there any objection to what I just stated? And the morons will look at each other back and forth, and then the district attorney will probably start coughing and realizing how fucked he is. and we'll try to say something to the judge like, Your Honor, I move for, I come upon a verbal motion of competency, or something like that. They'll try to throw you under the bus with psychology. And just say, objection, Your Honor. I don't know who this man is, and he has no business in front of the court until he proves that he has a higher claim to the res defendant estate, which is named herein. And then usually, if the judge is smart, he'll tell him to shut up, or he'll just dismiss the case. But it's not always that easy, because these people, one, they don't want to give up their citizen slaves, and two, a lot of them, honestly, on the lowest level, a lot of them do not fully understand how the basic backbone of how this system is run, and that everything's being run through equity and chancery courts. They just don't get it. Now, I have documentation and proof from a judge's manual out of at least one state, Georgia. We looked through a judge's manual one time, and a colleague of mine said, "You won't believe what I found." I was like, "What?" He said, "Look in this," and he said, "Look at page whatever." And in the Georgia judge's manual, it said that they were running traffic court through probate. And I was like, "Wow." I was like, "That's telling." But anyway, other examples. Other examples of administrating one state. Fidelity. Fidelity holds a bond in the amount of hundreds of millions of dollars that has a CUSIP number that's directly connected to your birth certificate. That is administration of your estate. So guess what? You can serve Fidelity and get that bond back. And if not, you can put them under $300 million of liability the other direction. I really don't care. I don't know what the DTCC may be holding, but that's something that somebody else can do too. They can serve the DTCC along with a claim form, because the DTCC has some fairly straightforward claim forms that are not all that difficult to fill out. And I'd fill out one of those, and along with the doc set, and serve them the whole bloody thing and see what happens and what they come back with. Another example of administering your estate. If you own land and you've done the declaration of allodial lands of the Vocational Science of Freedom, and they try to issue you a property tax bill, which is never a bill, it's always called a statement, which is why it's never lawful. You have to pay it. It's not a bill. It's not a true bill, because they can't issue a true bill. So all they do is they issue statements. But anyway, they'll try to get you to pay, say, property tax on allodial land. That's a form of administration of your estate. Hell, a parking ticket is a form of administration of your estate, honestly, as long as you've claimed your conveyance and it's still not actually registered to the state. But technically, after you get your doc set done, you've basically claimed it back anyway. But there's a more specific thing that you can do with the Secretary of State to make sure that the car is out of their hands and that there's no question regarding that too. But anybody else got any questions? Or Gary got any more questions? Okay. Yeah, and if nobody else has any other questions, pretty short Q&A. If you guys think of any questions later, if you want to rewatch this, eventually this will get posted up into the VSOF free civics classes, whatever they call these things on YouTube. Whatever, not the channels, but the playlist. Sorry. So yeah, it'll pop up in the VSOF free civics class playlist, and if you want to rewatch it later or send me any questions, you can do so. And anybody who might be watching this on YouTube, if you want to actually ask me a question, you can ask me a question directly in YouTube, because all you have to do is click on the discussion section of the Vocational Science of Freedom, click on discussion, and just drop me a question, and I'll see it and I'll respond to it. So with that, if no one else has any other questions, thanks everybody for coming, and I'll have this posted up on YouTube as soon as possible, and hope to see all you guys on Wednesday night. And if you have any other questions, you can always send me a personal message, a DM, on the Gilded server if you have any questions, or just chat in the old main chat where we have pretty much our running discussion for many a week. So with that, thanks everybody for showing up, and I will talk to all of you later. Have a good night, guys.